Hi folks, my name is Ben and I'm an attorney in Texas, and while I am an attorney, I'm not your attorney, so nothing in this video should be considered legal advice. But as an attorney here, I practice a lot in the world of CPS, and for those of you who are fortunate enough to not know what CPS is, it stands for Child Protection Services, and it's a wing of the Texas Department of Family and Protective Services. There's an APS as well, but I don't do much with that. Um, and so many people know what CPS is. It's the agency that of the government that is supposed to kind of monitor keeping kids safe. And it's full of a whole host of problems. Um, and there's broader discussions on what it means for the government to have a stronger interest in your kids than you do, that should be talked about. But for this series of videos, I wanted to get into the problem is that most people don't really know what CPS is, um, really how it functions. They don't know what the laws are related to it, and there's not really any way for them to know until you're involved, and by the time you're involved, it's way too late. Um, and then for certain, nobody knows what their rights are when it comes to CPS, particularly when CPS is trying to take your children. And so there's a whole host of problems with it that need to be addressed, need to be fixed, but the masses, the majority of the people who would vote or lobby in front of the state don't even know all the problems that are going on within it unless somebody from inside tells them, and they can start thinking and move forward. Um, and then in criminal law, most of us at least know our rights when it comes to engaging with law enforcement, the cops, if you get pulled over. We've heard TV and the movies have made it famous. Usually in grade school or certainly in high school, there's some knowledge of our rights. Most of us have had to read the Bill of Rights to the Constitution at some point. And so, particularly the Miranda warnings, which are, you have a right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you can't afford an attorney, one will be provided to you. Um, and but nobody really knows what their rights are when it um, comes to CPS, when CPS knocks on your door. And so the first thing that I want to tell you is nobody should talk to CPS by themselves without an attorney. Um, and there's two reasons for this. The first one is, and I don't want you to know about this, but CPS keeps a blacklist. So anybody can call into CPS and make a report for anything they want, okay? And up until just recently, they were to remain anonymous. Now, the legislature has been working on, here in Texas, trying to limit that, but they still haven't done a really good job of it. So anybody can call into CPS, there's a hotline, and report any kind of abuse. One of the problems is there's no immediate vetting system for who's calling. So in family law, a lot of times it's exes or soon to be exes calling. Um, so there's no vetting process for the report as to whether or not it's valid. And then second, it's very unclear what abuse is. I mean, we all have this idea of what child abuse is, but it's not really nailed down and specific. So, one of the things that happens all the time is, um, well, that kid just looks skinny, like he doesn't get fed much. Well, that's very subjective. Or, well, this kid's always dirty. Or this kid always has bruises. Um, or this kid watches too much TV. I mean, all of these are allegations that get made. So there's a fluctuation in what is abuse. So you call, CPS has to make an investigation, and it goes through a couple of different systems. But once an investigation has been opened, they're within the CPS before you even get to a court. A CPS has three determinations that they make. One is ruled out, which means they have looked into it and determined it was flat out wrong. That what was accused could not have happened. The next one is unable to determine. Unable to determine just simply means we don't know, and we can't know. So usually they don't go forward with it after that. And then the third one is what's called reason to believe, which is, and remember at this point, no court has been involved. These are just CPS personnel that decide that you get reason to believe. And when you have a reason to believe finding, then that gets locked away on a special list. And that special list that's kept only by CPS, it's not available for the public, which you might say, well, that's good because then random people can't go look at it. But it also means that there's no policing of it. There's no oversight of this blacklist that they're keeping that determines who can adopt, who can be a foster parent. If something happens to, say, your siblings and their kids are there, so your nieces and nephews are available, and they didn't have a will or a guardianship provisions for their kids, and you want to be considered to take those kids and raise them, but you're on this special little list that no court has had a hand in, you're either not going to be able to do that, or it's going to be very difficult for you to be able to do that. So that's, first off, why most people don't even know about that list. And so then something happens, a report gets made, and they come in and they start talking to CPS, and usually they're very nice on the front end, and they say, well, this has happened, we're sure it didn't happen, but let's just sit down and talk. And not only are you not aware of the consequences of what talking to them could lead to, you're also not aware of the code words and the checkboxes. So CPS is a government agency, and it's all done by checkbox, right? So you have a individual that's been hired, usually, not always, but usually they go in with good intentions, but they just see this stuff over and over and over again, and they're just there to fill out the boxes. It is just like going into the DMV. And you don't know what their checkboxes are, and it's not what they tell you it is. And so you have to be very careful with them, and you are playing a game you don't know the rules to. And so very important that you speak with an attorney before you talk to CPS. And here's what that looks like. They say, hey, I'm from CPS. I'd like to talk to you about X, Y, and Z. What you say is, I'm happy to talk with you, but I want to talk to an attorney first. And you go and you find one that day and talk to them. If you already have an attorney, you give them your attorney's card and say, I'm happy to talk with you. Make an appointment through my attorney. Done. You're locked up, and then you can get some advice. You can know the games that you're playing, and you can begin to control that situation and making sure that what you're saying is what you really want to say. The second reason, and much more important, is CPS has the power to take your children away from you, even temporarily. And you can't really stop that from happening. And so, look into the psychology of particularly women, but women and men too, just families, of what happens to your brain when your child, particularly an infant, but your child is taken away from you by somebody with a badge. And you are no longer thinking. You are in panic mode. And now, so remember I said if you get arrested by the police, then they have to tell you you have a right to remain silent. Anything that you say will be used against you, and you have a right to an attorney. Well, CPS doesn't tell you any of those things, hardly. They do. There's one little line in a list of forms that they hand you that says you can talk to an attorney. Now, So it's been determined that if you're a parent and they want to terminate your rights, right? They want to legally make you not part of your kid's life, or if they are distancing you from your kid without your agreement, putting your kid, sometimes they'll put them with family or in the foster system, then you have to go to court and you get an attorney. But that is way downfield. Now here's the issue. Um, they will also use anything you say against you in court. And even though it's technically a civil suit, a civil case, um, there are rules that are called hearsay laws, right? So in court, you're not allowed to present something that somebody else said unless they're a party opponent. So anything that you say, they're going to write down and they're going to say it in court. And it's not going to be recorded. Anything you say is going to come out. And there's two things. Generally speaking, something very traumatic has happened to you. You have had, I think, well, extremely traumatic to have your kids ripped away from you and to be called a bad parent. And those two things mean you're probably not going to remember what you said, and you will say anything you think to make it stop. And then the second problem with that is that there's no way of enforcing. So by the time you get to court and you have an attorney appointed to you, there's no way for me to say when they start talking and you're going to whisper in my ear, you're going to say, that's not what I said. All I can say at that point is, well, that's not what she said. Because you're not going to remember what you actually said. And even then, you're in a swearing match in front of a judge where you're saying, well, that's not what I said. I actually said this, that, and the other thing. They're saying, no, you absolutely, this is exactly what she said, and that's why I took the kids. And you can't get around that. What they're going to do, just like the cops do, is they're going to take bits and pieces of what you've said. They're going to string it together in the story that they want to play out. And then that's going to come up and be used against you. And the only way to stop that is to make sure that you are talking to an attorney. So what do? When CPS knocks on your door, you do not have to let them into your house unless they have a court order that says that they're there. And generally speaking, that has to be run through an attorney on your behalf at some point before it actually manifests. And if they do have the court order, then the attorney can come back through and say, well, the court order specifically says you can go here, here, and here, or you can do this, that, and the other thing. When they do those things, then you can begin to challenge that, right? So you do not have to let them into your house. You do not have to let them talk to your child, and you don't have to talk to them. And so, again, what you say is, I'm not cooperating until you have a court order or until I speak to my attorney. Thank you. And then you close the door and you leave it that way, okay? Another thing you need to make sure that you say is, you do not have my consent to speak to my child. So then, you come in and you talk to an attorney, and as soon as that happens, it calls their bluff. They either have to make it to a case or they have to leave you alone, right? Because your attorney's going to say, no, we're not telling you anything. Either you have enough evidence on your own without making my client give you more, or you don't, and you need to go away. So, never talk to CPS alone. And here's the catch. And this is why you need to establish that as a rule. Here's the catch. They might take your child. They might take your child. Just like if the police violate your rights when they arrest you, you're still going to jail. Nobody's fighting their way out of that. Nobody's talking their way out of that. That is happening. But you have a stronger chance. If they take your child, you will get into court. At that point, you will be appointed an attorney. But you have given them none of your own evidence to use against you and to manipulate in such a way that you can't fight it. So today, I've been doing this for 7 years. I am on the appointment wheel, so I get court appointed at the time that a child has already been removed. I'll get appointed to help those families. Very few, in my experience, very few of those people end up getting to keep their kid long term without some major gap of separation between them and their kids. So several months. Um, but to date, no one who has called me from the first interaction with CPS has lost their kid for any period of time. Um, and that you win some and you lose some, and that's always subject to change. But thus far, that's the power of having an attorney when you talk to CPS early on. It forces CPS, one, to do the work, and two, to be honest and upright in what's going on without cutting the corners. Never talk to CPS without an attorney.